A very good morning to all the participants of today's program. It's my privilege to introduce today's speaker, Mr. Anil Kumar Dubey. He is a distinguished fellow member of the Institute of Company Secretaries of India, a practicing company secretary, and a registered valuer. He is also an insolvency professional with specialized expertise in company law, insolvency, securities law, valuation matters, and NCLT appearances. His academic credentials are equally impressive, holding a diploma in international arbitration from the University of Vienna. A well respected academician in corporate law and training, he is known for his dynamic and enthusiastic approach, which inspires his team members to realize their full potential. His leadership was recognized when he was elected to the esteemed India Regional Council of the Institute of Company Secretaries of India for the 2019-22 term, where he served as secretary in 1920 and as chairman for the 22-23 term. Mr. Dubey, I have heard that arbitration is going to be very big thing going forward, and especially looks like the present government is more keen to make international arbitration. They want to attract international arbitration to India, and this is what I have heard. So I want to know what you feel the future about arbitration, and then the stage is yours, virtual.
Yeah, thank you, ma'am. Let me first share the PPT and then we will discuss on technical setup should be ready. Is it visible, ma'am?
Yes.
Is it visible, ma'am? May I proceed?
Yes, yeah, but not in slideshow mode.
I'm trying to really set up slides. So, coming?
Now it's fine.
Yeah. Thank you. First of all, thanks all the participants and organizers for inviting me and giving their valuable platforms to share my insights. Because today's topic is little bit the combination of two things. This is not the one, that is a valuation, and second is a how it happens, particularly in arbitration matters. Not particularly in the court matters. Courts matters I'm deliberately, because the time slot is less. Therefore, I'm focused only on the arbitral tribunal. As friends, we know that why we should go for arbitration. There is a one domestic arbitration, another is a international arbitration, international commercial arbitrations. More focus will be the in international context, how the international things happens, because we know how things happens in Indian context, the arbitrations. The biggest advantage, anyone parties wanted to their insights, they can come. I have put in the chat box. I will be able to I will try to keep the sessions interactive. Why we should go for arbitration? The first questions. If you go to any client, or we are going into any investment agreement or any commercial contract with anyone, first point, why should we go for arbitration? What is the need for it? Okay. Dispute. A lot of things are the very theoretical. It's a cost effective, it's flexible, it's a timely, everything else. But the one very important factors which people forget it, if there is a decision of the domestic court, then you have to go to another country, and enforcement of that court order is nightmare. It's easy to get the order in domestic setup or a domestic judicial system, but recognition and enforcement of that order in foreign country, suppose some court in Chile, some court in Mexico, some court in suppose any part of the world, giving some order against some Indian company, and that party coming to India to enforce that order is as a professional, we know how tough it is going to be. Despite having all the technology, all the advancement, no one wanted to go into that uncharted path, uncharted territory. Okay, so how, as same thing may happen for our Indian clients. If some Indian clients is going to some other countries being set up, and how they are going to protect their interests, that becomes very, very important. In this case, what happens in commercial arbitration, international arbitration, there is a convention called New York Convention 1958. There is 172 countries signatory to that, almost the whole world. And in that convention, what happens, ma'am, and the dear participants, that is a, you can enforce your award in 172 countries, and it's automatic. Very limited ground of non-refusal to recognize that award. Else, this is a very, very important mechanism if you are, because the benefit of New York Convention is not available if you're going to normal judicial system. The benefit of the New York Convention is available when there is an arbitration, because it is only recognized arbitration. And there is a lot of other arbitral institution like the ICSID under the aegis of the World Bank. If you're going to this is one step above the New York Convention. If there is any arbitration award under the ICSID, that is a international commercial settlement of dispute of under the World Bank, this is very, very important, ma'am. Even that arbitral award does not need any recognition or enforcement. It is ipso facto enforceable in the whole world. Just imagine the kind of a legal force arbitral awards getting it. Normally, you can go for the New York Convention, but if parties are agree, they can go to the ICSID also. That ICSID Savar are very, very powerful tool to enforce anywhere in the world. That is why the parties in the international commercial arbitration contracts prefer the arbitration. This I am telling with the point of view, all other benefits are there. We normally read it, it's flexible, it's a time there is a flip side also. Flip side also is that arbitration is a costly. If anyone thinks so that arbitration is not costly, that is not right. Arbitration is very, very costly because the best of the lots are in the field, and that is good for our professionals, but not good for that to the client, because in I have seen that a lot of matters, if parties are not financially viable, then we should not advise in routine matter. We should go with the requirement of the client, and then recommend them either go for the domestic judicial system or arbitration. But if the stakes are high involved, then we must go for the international commercial arbitration. Now, the point of today, as a valuer, what is the role of in our arbitration? Arbitrator will be like a judge, advocates will be there, parties will present their case. So why, as a valuer, we are come into the picture? We will discuss in that point. Let me go with my presentation. My screen is available or not, ma'am?
Pardon?
No,
My screen is
it's not
available or not?
moving. It's not moving.
Just a minute. It's moving, sir?
Yes, sir. Now it is moving.
Thank you, sir. As you know, the wars will remain while human nature remains. Okay, no one wanted war, but we know that if there is an agreement, there is a contract, then every possibility is that there is going to be dispute. Okay, both the parties is going to read that document, that contract, that situation in their favor, and that is nothing wrong in that. Okay, as a parties, they are entitled to, but that entitlement should not going to prejudice the interest of the opposite party. That is the root cause of any kind of dispute, not just the arbitration. Role of valuer during arbitration. The first point where the valuer come into picture into the arbitration proceedings, by definition, valuer is an expert. And there is a lot of experts, domain experts, financial experts, valuers come into the during the arbitral proceedings to assist the arbitral tribunal as well as the parties. These two words are very, very important, friends. I would like to know the meaning of anyone who can share what is the meaning of these two terms. Damage versus damages. Okay. Sometimes we use it very casually without going into the merits, but these two words will come again and again. Okay. And during today's discussion, okay. What is damage and what is the damages? Anyone wanted to share their insight? Damage and damages.
Damage is a loss, and the
Yes.
damages are the the compensation which somebody has to pay. Liquidated damages.
Yes, truly correct, sir. Thank you. This is a very, very correct word. That's a damage. The parties suffered their loss. Okay. And damages, then their entitlement to claim compensation to the opposite party. Okay. So as a valuer, our role is twofold. When we come into the pictures, first, we have to come to decide the quantum of the loss. That is called, sometimes in certain jurisdictions, we valuers are also termed as a quantum experts. Okay. How they are going to decide how much loss suffered to another party. We have seen very mechanically in India, if something happens, people list lot of things. Okay, this happened, that happened, this also happens, this mental trauma, and they make a big list. Okay, and that happens also in the arbitral tribunal. So sometimes what happens, valuer is services are taken by the parties as well as the tribunal. Okay, to actually decide what is the quantum of the loss suffered by a party. And the second point, after the determination of the loss, after the quantification of the loss, how much compensation arbitral tribunal should give to other party, that becomes very, very important. So by all the friends, these two words, I have seen a lot of even professionals using this word, okay, very casually, meaning both the things are the same, but in legal parlance, in technically, both the things are different. So just for the today's discussion, if no confusion, I will use more as a compensation, okay, rather than damages to avoid the confusion. Role of expert witness, okay, because as a valuer, frequently called to the arbitral proceedings to testify as a witness. And testification is very, very important as a valuer, and this very, very technical job, because there will be examination, there will be cross examination, there will be re-examinations, and at that time valuer has to stand to his conclusion. What is the logic, what is the his assumptions taken while quantification of the loss, or for the valuation of the particular assets or shares, whatever they may be, they have to be thorough, because you opposite counsels who is not going to rely on your report is going to discredit before the arbitral tribunal like anything. Therefore, it's very, very important as a valuer, if you're going to testify before the tribunal, we should be very, very thorough. The role of experts is fundamentally to provide assistance to the decision maker. Who is the decision maker here? Normally it's a court, but in the arbitral proceedings, it's the arbitral tribunal or arbitrator. In relation to the expert's area of expertise, that's fine. This will usually be in relation to areas where the tribunal and lawyers do not have the requisite expertise. Normally what happens, if some valuer is appointed as arbitrator, so therefore the arbitrator services will not be required. But if the judges don't have the technical expertise, or the advocates don't have the technical expertise, therefore to assist the lawyers or to the court, okay, frequently I have seen in the commercial arbitration, it's normal norm to engage the valuers. Then next question arises, okay, who will appoint valuer during arbitrations? Okay, it's a tribunal appointed or versus a party appointed. This is very, very important. Okay. For the timing, I wanted to open this questions to all the participants. I wanted everyone to share their views. Okay. One by one.
Whoever is the arbitrator, he will appoint valuer.
Arbitrator. Ma'am is saying arbitrator is going to appoint the
Valuer.
arbitrator. Okay.
Valuer.
Again, evaluator, sorry. Okay. Again, any other views?
It may be by the tribunal also.
Maybe. Well, it's may party can
I think
also
it is
appoint.
the tribunal. The tribunal will empanel the valuer, and then
Okay.
you can identify whoever you want. They will be given an option. These are the valuers, and
Options. Okay.
select from the valuers.
Any other view?
Where there is a dispute in the valuation, in the valuation report, submitted by the valuers, appointed by the parties. If they don't concur, then the court may intervene and then appoint another valuer.
Okay. Good point. Any other perspective on this?
Anilji, generally, what I have seen in the agreements that the parties who are there in
Yes,
the contract,
yeah,
they says that there would be one party from the seller side. Just to give an example, one
yes,
party from the buyer side who will be an arbitrator.
yes,
And if both are not abiding to what that arbitrators are saying, then
yes.
a third neutral arbitrator would be appointed and whose decision would be enforced,
Fine,
would
yes.
be enforceable.
Yes, sir. Yes, sir. Yeah. But this is regarding the arbitrator, sir. Okay.
Correct.
We are focusing on the valuers. The arbitrator is like a court. Now the question arises, if some witness valuer is called to determine the loss or to give the amount of the compensation, okay, in their professional opinion, so who are going to appoint? Is the party, both the party will appoint their single valuer? It is also possible. This is the first situation. Or both the parties may appoint respective valuers. That is the second options. And third options is whether the tribunal can appoint it or not. Okay, because every option have there is pros and cons, and also the subsequent cost impact on the arbitral proceedings and delay also.
So
therefore, as yes, sir.
Sorry, you continue, sir. Sorry.
Yeah. So this point is very, very important. Principally, both the party can appoint the valuer, no problem. Even the tribunal can appoint the valuer, there is no problem. But point arises why if the parties will appoint, there is apprehensions that they will give their valuations in favor of the parties who appoints them, or it could be the party man. Okay, so this is going to vitiate the entire proceedings. Okay, that is very genuine apprehensions and concerns in this matter in case of party appointed valuer. If there is a valuer appointed by the tribunal, okay, so what happens? This is going to part of the cost of the arbitration. This is going to delay the proceedings because everything is very time driven. And when you go in the international commercial arbitrations, even the 5 minutes are very, very important. Okay, the costing is very, very high. In this situation, as a professionals, what is the best way? Let's discuss one by one. First point, sir, in case of the party appointed arbitrators, there is no prohibition at all. Okay, party is entitled to present their case with evidence. Okay, so what happens if there is a certain questions where I am not sure, I can engage certain valuer to give me the professional opinion, professional assessment, so that I could present my case before tribunal with evidence. That is the first point. Regarding the concerns raised in everyone's mind, if I am appointing a particular valuer, the particular valuer give me the convenient value. Okay, here this is the important one. Guidelines comes into picture, that is called IBA. Okay, International Bar Associations, in case of applicable internationally. That the first point is that in case of party appointed valuer, valuer is need to be independent from the party. Your professional independence compromise will not because someone is appointing you. That does not mean you are going to by the dictate of the party. You have to be thoroughly professional, independent, objectivity. Same example like an arbitrator. In arbitration, what happens? Both the parties appointed respective arbitrators and respective arbitrators appointed third arbitrators. The respective arbitrators appointed by the parties are not the party representative in the arbitral tribunal. They are independent from the party. They have to behave like that. And there is a thorough guidelines on this. IBA guidelines are there. Today's time was restrictive. Therefore, I'm just giving the passing reference. You can go through. That is a red list, orange list, and green list. That determines regarding the conflict of interest, objectivity, independence of the particular arbitrator vis-a-vis valuer 2. Because that is applicable not just to the arbitrator, but to the expert also. There is certain red list. If this kind of conflict of interest exists, that kind of arbitrator or valuer cannot be engaged by any party. There is a orange list. That is if the party is waived, only in that situation the arbitrator or valuer can act in that proceedings. And there is a green list. That means there need to be disclosure. And if there is no substantive matter, then the valuer or arbitrator can continue. You just note that on IBA. I will share it separately, the complete PDF file containing what are the green list, what are the orange list, and what are the red list. This is a very, very important. Therefore, the concerns raised that valuer may be the party man. That is not going to be true, because in practical life, they behave very, very professionally. In international context, I have seen some transcripts of the arbitral proceedings. I was really surprised the quality of the professionalism showed by the valuer in that matters. Okay. Honestly speaking, that is not being followed in our country. Sometimes we are very obliged to the client. If he's going to be inconvenient, he will not going to hire it. Okay, sir. If our reputations get us the assignments, not the sometimes the networking. Therefore, in commercial arbitration, it's very, very important that in case of party appointed valuer, valuer is not a party representative. He has to maintain his independence. He has to maintain his credibility, and he has to maintain his objectivity. Because if your objectivity and independence is going to question by the opposite concept, because he's going to be do PhD on you. Who are you? From where you are coming? Why the other party has appointed you? Okay. And if there is any kind of conflict of interest, he's there, he will grill you during the cross-examination. Literally, the happens in like the court proceedings. Therefore, the kind of apprehensions that is being addressed in this way. Therefore, party can appointed. What is the benefit of the party appointed arbitrators? Because it is done before the commencement of the arbitral proceedings. And it is not the part of arbitration cost. What will happen is arbitration cost, both the parties need to split the cost 50-50%. Okay, unless otherwise provided. But if the party appointed arbitrators, party will pay the fees, and it will happen before the commencement of arbitral proceedings. It will save cost during the arbitration proceedings. But there is also viewpoint that the tribunal can also appoint the valuer. That is very inherent power. Okay, unless sometimes there is specific agreement. In some clauses, I have seen that. Okay, that is a different issue. Else, there is no prohibition. Arbitral tribunal can engage. There is also a problem. He should engage one arbitral valuer, or because the valuer, every valuers have a different perspective, different values. If you go with the one valuer or three valuer, okay, that depends upon completely open to the discretion of the arbitral tribunal, how they wanted to go about it. Therefore, very, very fundamental, party can appointed the arbitrators, but in case of party appointed arbitrators, their objectivity and their independence will be judged as per the red list, orange list, and green list of the IBA. Any questions up to this point?
Yes, sir.
Yes, yeah, please.
Good morning to everyone, sir.
Yeah,
As
good morning,
you
sir.
said, as you said very rightly, the valuer should be unbiased, it should be appropriate professionals.
Yeah.
But in our country, unfortunately, this is totally unorganization sector, the valuers. Number one.
Yes.
Number two,
Hmm.
valuer having a proper knowledge about the valuation and the assumption limitation. Nobody want to pay his fees as he desired. They try to hire a valuer who can charge minimum fees, who don't know anything. He became a totally always biased.
Yeah.
Even though after knowing the fact also, he tried to dance on the tune of the paymasters.
Yes.
Where the all professional and the reputation of valuer go into drainage like that is a very unfortunately painful. I'm sorry to share with and disturb you. Sir, this is the present situation in India. Why we valuer is on the back foot and being painted with the black, let me tell you, painted with the one brush, something like that only. And we all are paying price for our honesty, experience, and the knowledge also. That is I want to, because put my view before you, sir. In
Yes,
this
sir. Sir, what's your name, sir?
My name is Mr. Navraj Nehra. I am from Mumbai.
Okay.
I am a government registered valuer, mechanical engineer.
Thank you, sir. Thank you, sir. Because the truth is always bitter. I appreciate your honesty. But, sir, your concern is very, very true about the domestic systems. But believe me, in international arbitrations, it's not. Values are paid very handsomely. Okay. If you get your luck tried in the international commercial arbitration, all your apprehensions are, you will not say, you will be very happy. Okay, because I have seen go to the costings given by them, and I'm saying even 1 year, if you're getting 2 to 3 assignments, you will be more than happy. So the
Sir,
kind of concerns, that's agree, totally agree, is happens in domestics.
Only
Yes,
one point, sir. I don't want to name the arbitrator.
Yeah.
Very, very senior and prominent who has been a judge of the High Court, chief judge, and he was the judge in Supreme Court. I don't want to disclose his name. He has taken my services and he has paid me very handsomely. He did not ask what is the breakup of the bill. Whatever bill I raised, he told his stand pay immediately.
Yes. Yes.
That was the arbitrator in India only, sir.
Yes.
I don't want to name that he was retired judge of Supreme Court. He was the chief justice of one of High Court of India. But I don't want to disclose. He's a very good arbitrator. He has a very good reputation in your fraternity.
So point happens, India is a very big country.
Yes,
and a lot of experiences will happen. Some good, some bad, some average. That's, as a country, we have to accept it. Because what is happening in Bangalore, Kolkata market may be totally different from Bangalore. Bangalore may be totally different even from Chennai. Even sometimes Mysore, for the land and building valuers, even the market of Mysore and Bangalore will be different. So that's totally agree. But I think that standardization will take some time, because the valuation professions in other countries are having the 50 years track record. But we are just in the nascent stage. So these things will happen, and it is part of the development. But agree, no one wanted a forthright and independent person in India. That observation is totally agree. Okay, because everyone wanted yes man. Okay, what my personal experience, I have seen that everyone wanted yes man. No one wanted everyone say it, but actually no one wanted it. That problem is with India. That's no doubt about it. Yes, sir. Kaji sir wanted to say something.
Let me tell you.
Yes, sir.
In international arbitration, there is a huge respect and there is a huge demand for quantum experts.
Yes, sir. Yes, sir.
And those people are so highly professional. When they depose before the tribunal, they give the opinion as to why they have taken a particular rate of interest and what are the discounting factors, how exactly they have arrived. And then they give the opinion, what is the quantum of damages. And then they are subject to some cross-examination, which they do very nicely. So they are in very good demand and they are highly respected and well paid.
Agree.
Hopefully, so slightly that effect will come to India also, Mr. Mehra.
Yes, sir.
And sir, what happens, Mehra sir? That's sorry, Nehra sir.
Yes, sir.
Yeah. What happens? The international arbitrations are basically governed by a lot of arbitral institutions, like Singapore International Arbitral Center, Vienna is there, ICCC is there, CIRB is there, and they have internal rules, mechanisms where the scale of fee is decided. This is not open to negotiation between the parties and something like that. It's ipso facto. That kind of independency is guaranteed by the arbitral institutions whosoever govern it. India is not having that kind of standard arbit. We have a lot of in numbers, but in quality, but in practice, we don't have any. Okay.
Correct.
For example, all the commercial arbitrations in India, Indian part, both the parties are Indian, but they are being handled by the Singapore International Arbitration Center, not in India. Okay. For example, I was in Europe. I have seen that two Middle East guys, they are deciding their dispute as per the Swiss law. I was just laughing like anything. Okay. but the kind of they have made their systems. If the Singapore can have a, such an outstanding arbitral institutions which can compete with the ICCC, Vienna or London, everyone. As a country of India, okay, I think Mumbai should have been have one institutions, but so every industry body in India have their arbitral institutions, but there is no internal mechanism, no assignments going on, nothing, no research work is just for the sake of publicity or some statement. We have arbitral institutions, but it's not actually working. That's totally agree with that. Government is working. Government is working in this.
I completely agree with your view, sir. I indulge it, and you are very practical. I really appreciate.
I agree, sir. The things, because if you can't acknowledge the problem, sir, we cannot state the problem, we cannot solve the problem. I strongly believe it. First, we have to accept what is the problem. Okay. Then the second step is the solutions. Okay. Let's again, sir, coming. Thank you for your insight. Let me again.
Thank you,
sir.
Yeah.
No, thank you, sir. Thank you. Coming to that, duty of independence, even party appointed experts need to be independent. We have already discussed it. Tribunals are very critical of the hired again and will find their evidence less credible, give no weight. So that if you're appointing someone who have a very conflict of interest with the party need to understand that they are paying to the valuer, but he will be cross-examined by the opposite counsels. And if his testimony is not credible, their entire report will be ignored. The party, it's very, and it also creates a doubt about the integrity of the party before in the tribunal's mind. Therefore, as a party, we need to be very, very careful not to appoint your yes man or having their close affairs with the party. So this is very, very important. Next is a valuers examinations. Yes, this is a, I think, nightmare for the valuer. Okay, if no one has, I witnessed one testimony, and at that particular moment, sir, I really decided in my mind, I am not going to be valuer in the international arbitration. The way they are going to grill it, this is really, have to be very, very thorough, very, very professionals about your report. That means entire report should be borne by your own thought process. Every comma full stop. Why this is? What are the other alternatives? Why we chooses this method? Why not other method? Why? And particularly they go after the assumptions. Okay, because as a valuer you have to make certain assumptions, and reasonableness of the assumptions are going to be very big. They have the entire global comparison set, so all the opposite 5 to 6 councils are going to grill it. Therefore there are certain valuers, I would not like to name it in the international sphere, because they gone their reputations because of their sheer hard work. They stand the testimony, and arbitral institutions taken their testimony very, very seriously, and they're very thorough professionals. This is very, very important. In legal proceedings, sir, what happens? There is a valuer may be called to participate at a scheduled hearing. Normally, the hearing takes place at the venue or the seat of the arbitrations. In commercial arbitrations, these are the maybe the any world capitals. You are going to, this is the plus side. You have to be visiting the very 5-star hotels and very good locations. These are the upper side, but in mentally you have to be very, very careful. If you are any valuer having the experience of testifying before the court here can share their experience. Anyone? Who has, even in India, not in arbitrations. Kiran ma'am, I would request you to invite someone, some valuers, okay, who has the experience of testifying before the court or arbitral tribunal, okay, and because this is very, very technical and a specific job, they could share it, because I have witnessed it. I did not given any testimony before the court, but I have witnessed and go with the transcripts, and I at that particular moment I decided this is a very, very tough job, okay, and the kind of the grillings happens. But as a valuer, we, if you have done our job thoroughly, we can stand that. If anyone who has done this, so please invite them. My humble request to you, and because that going to a different insights and perspective to how to handle the testimony as a valuer before the arbitral tribunal, or for even that matter before the court.
Yeah.
Next is if the procedure is adopted, the next step is to cross. There is a 3: examination, cross-examination, and re-examinations. Anyone has heard these terms before? These are pure legal terms. Examination, that means party's witness are being introduced before the court, and the party who brought the witness first examine them, and then opposite counsel is going to cross-examine them. After the cross-examination is over, then the same party who brought the witness is going to re-examine them on case of the points of the conflicts. That is a basic judicial proceedings. This is the trial phase where happens, and arbitral tribunal also go with the same method as the court.
Could you please repeat, sir?
There is 3 methods in the judicial proceedings during the trial. First is called examination map. Second is called cross-examination. And third is called the re-examination. How these 3 stages works, suppose someone appointed me as a valuer in particular matter, and he presented my report before the arbitral tribunal. That what happens, he will represent me, my report, or he can request my personal presence before the tribunal, and he will ask certain questions to me before the tribunal or the court. This is called the examination, because the party who appointed me is going to ask certain questions before the arbitral tribunal. Then what will happen? After the examination is over, the opposite counsel will come. He will ask me certain questions. That is called cross-examination. Okay. After the cross-examination is over, if there is a point of conflict, then the counsel who, the party who has appointed me, who brought me before the tribunal, again going to ask certain questions to me. That is called the re-examination. So therefore, this examination, cross-examination, and re-examinations. Any question? Any question, friends? Or may I proceed?
You can proceed.
Thank you.
You can proceed, sir.
Thank you. Thank you. Valuers conference. Sometimes if there is more than one valuers, what happens? Where 2 or more valuers are used, it is possible to direct a witness conferencing so that the experts can be simultaneously examined in relation to the same issue or issues in dispute. Such a procedure is likely to reduce time and cost. That is also happens in certain, particularly in ICCC, okay, in Paris. They go with this kind of a mechanism where valuers conferencing is very, very common, or witness conferencing for any particular matter. They just figure out the point of contentions between the 2 experts, and they are going to focus on the points of conflicts only. Suppose, for example, someone is applying discount rate 15%, someone is applying 25%. Why 15? Why 25? Someone applying DOLM, suppose 40%, someone is applying 15%, someone is applying 70%. Why it is being done? They just go the point of the divergence between the 2 reports to save the time. General requirements. Is the valuer free of conflict of interest? Is the valuer actually done the valuation assignments relating to subject matter of the dispute? What is the intended valuer's experience? This is very, very important. Does the intended valuer have experience testifying? This is very, very important. So, because a lot of valuers who have not testifying, they don't have the experience. Therefore, their statement sometimes tribunals takes seriously. Here, but if some certain valuer who have a lot of experiences, they can manipulate it. It can be both the way. sometimes having experience is good, sometimes having experience is not also good. Therefore, which situation is suits our requirement, that need to be decided in advance. Any questions? Any questions? Okay. What is the intended valuer's track record? This is very, very interesting. Okay. I asked these questions to one of professor, sir, how to get the assignments as an expert or as a arbitrator in the international arbitrations. He replied in me beautifully. Okay. He told me it's very, very easy to get the first assignment. There is no problem. Okay. If you are good, you will get the assignments very easy. But it is very, very tough to get the second assignment. I asked, sir, why it is key? It's easy to get the first assignment, but it's not so easy to get the second assignment. He told me in the first assignment, because this entire international arbitrations fraternity is very small. It may be geographically very wide, but actually is very small. Everyone know every other person. In very first assignment, what happens? You are going to be classified, you are going to be labeled, you are going to be judged. You're good or bad, average, everything will be happen in the first assignment. Okay. And then accordingly, the fraternity or the stakeholders is going to work with you. Therefore, it's very, very important. You have to be thoroughly good in your the first assignment. Okay. So this is the, and in lighter note, he also told me, asked me, what is the full form of the mafia? Okay. So, sir, I told him, sir, I don't know it. Then he beautifully replied, mafia is a male and female international arbitrators. So everyone know every other person. Therefore, we have to be very, very careful while doing our the first assignment, because that is going to decide how you're going to have your career in the international arbitrations. So therefore, your track record, your independence, your credibility is non-negotiable in any way. Next is does the intended experts have the support of the team? Sometimes your team, how big team you have, you're working individually, you're professionally, what are your the infrastructures that also have an impact while before the arbitral tribunal, because the opposite counsel is going to have a lot of questions on these aspects too. Now coming to the legal principles in economic damage estimating. The first point will be the how to decide the quantum of the loss. Okay. Before going into detail, the first point is called duty to mitigate. We will discuss in detail on this particular point, because Indian law, also Indian Contract Act section 73, if there is a contract where there is a breach, that means if there is a party need to be have to take all the reasonable efforts to mitigate the loss. Okay, we will discuss in detail. Estimation of economic damages. Here, please read the damage, not damages. Okay, that's wrongly when they are accepted principles and approaches. How we are going to decide the quantum of the loss. So what are the principles and approaches in that regard? This is very, very important. Causation. What was the reason for the loss? Why the contract was breached? Okay, who is responsible for that? What caused the breach of the contract, and what that is the causation is very, very important to fix the who is going to pay the liability. Okay, reasonable certainty. This is very, very important. We'll discuss in detail. Selected appropriate method of measurement, lost profit versus lost business value. Date of breaches, this is very, very important. Period of loss or damages time period, and principles of mitigations. These are the these are 6 principles we are going to discuss regarding the estimation of economic damages. One by one, we will go with that. First is a wrongful act. And sometimes what happens, you did A, B happens. Okay, but sometimes what happens, you did A, then happens C, then happen D, then happen E, and then happen B. Suppose B is the wrongful act. Therefore, directly and consequentials, remotely. In Indian law also, if there is a proximate and direct, then the liability can be fixed. But if it's too remote, then the liability cannot be fixed. Therefore, it's very, very important when you are going to value any particular assignments, what caused the breach of the contract, why these things happened, whose conduct is responsible. That estimation is very, very important, because how much loss suffered is equally important. Who did the loss? That is very, very important. Did the defendant's wrongful act produce the damage suffered by the claimants? I said because of his conduct. So you need to prove that my conduct is responsible for the loss. Loss maybe happens because of 100 reasons, but my reason is 101, not that 100 reasons. So as a claimant, I have to prove that defendant's wrongful conduct produced the damage. So as a valuer, when you are going to estimate the quantum, you will very, very particular the conduct which caused the loss to the claimants. Causation is more than correlation. This is very important. That means superficial connection is not important. We have to get cause and effect. It needs a lot of analysis, lot of domain expertise, lot of research to corroborate that, because you are going to be grilled by in cross-examination on this causation aspect. How you have decided this wrongful conduct caused that particular damage. Valuer should make analysis of other factors that could have caused or at least contributed to claimant's damages. Damages for lost profits are recoverable only if breach, wrongful conduct was proximate cause of the loss. Okay, this is very, very important. Okay, because in a lot of as a claimant, I'm going to say every conduct of the defendant's wrongful conduct causing me loss, but that is not going to help me. I have to be very, very thorough in my analysis that this is the, because remote cause is not considered legally in any jurisdiction, particularly in the common law jurisdictions. Worldwide, we have two jurisdictions. We need to be very, very thorough about it. That is a common law and civil law. That is called in arbitral lex arbitri, which substantive law is going to decide the will be applicable, will be applied by the arbitral tribunal while deciding the disputes on merits. This is very, very important. That is called in international parlance lex arbitri. Okay, in Indian context we call the seat of the arbitration, which law is going to be applied. In some, if the common law it's approximate, but in civil law, some countries I have said that their level of approximate and remote is little bit different from the common law jurisdictions, particularly in the Oriental Europe. Therefore, when you are going to for the arbitration or arbitrations, you should that which lex arbitri is going to be applicable to that particular assignment. Let me explain it more better way. For example, in India, the common law jurisdiction says that parties has to bring the law and facts before the court, under which law you are approaching the court. But in the civil law jurisdictions, situations are totally opposite. They say that parties bring the fact and the courts brings the law. Their obligation part, they have just to state the facts that this is the fact and I am being prejudiced, therefore I need the justice. But in India, that is not the case. In India or any other common law jurisdictions, we have to state this is the law which protects my right. My legal right has been violated. I am being prejudiced. Therefore, I am before your lordship. Therefore, these two fundamental difference. The lex arbitri, that is the substantive law which is going to be applicable on the dispute on the merit, need to be borne by the valuer while estimating the quantum of the loss. Proximate cause, any act from which injury results as a natural, direct, uninterrupted consequences and without which injury would not have occurred. Okay, that is the proximate cause, and this need to be analyzed by the valuers in his report while estimating the quantum of the loss. This is very, what is direct? It should not be remote, direct and proximate. Any question up to this point? Then we can go further.
I think Mr. Arun raised his hand.
Yes, sir.
Arun? And there was a question in the chat also on Hyderabad
Okay.
Arbitration Center.
Okay, let me say it.
Yes, I raised my hand. This was when you asked if anybody has experience in representing a client's case in front of arbitrator.
Yes, sir.
So I happen to have one such experience in Mumbai,
Yes, sir.
and believe me, it's a very intimidating setup.
Yes, agree, sir.
So apart from whatever you said is all correct, and I'll just add to it. One
Yes,
is the way you are supposed to behave, the way
Yes,
you
sir.
are seated. The client is not present. Your client is not present in the room.
Okay.
Only the client's lawyers are present,
Okay.
and you're not supposed to talk to your client's lawyers.
Okay.
Whatever it is, I mean, you can only talk to the opposite, the counterparty's lawyers,
Yeah.
right? And they are only cross questioning you.
Okay.
And second thing is they will. So you've written a report long time back. The process
Yes.
takes time, right?
Yeah.
You've written the report long time back, and you've given a short notice to attend the proceedings.
Yes.
So let's say tomorrow you want to attend, you'll be notified maybe in the evening or something. You'll always be informed कि आज हो सकता है, कल हो सकता है, but never does. And so when you are least expecting it, you are supposed to be present.
Yes.
The counterparties, the lawyers, they question you on what is not written in the report as opposed to what is written in the report.
Agree.
And second thing is, there's a person who's constantly typing whatever you've written.
Yeah,
And
that's transcript, sir. Sir, just I'm interrupting you. The very good. I have experienced that. That's a lot of learning materials in that way. Sir, what happens in India? Lot of times, as a professionals, I've appeared in some tribunals, and in general, the advocates fraternity, they feel that what sometimes they argue that is not being captured in the judgment. Okay, yeah, they have argued something else, and completely opposite things being captured in the judgment. But international arbitrations, ROCs, there is a complete transcripts. Okay, whatever you are saying, ditto is being recorded. Therefore, that sanctity integrity of the documents very high, and that helps before the upper fora in the appeals. Okay, yes, sir, continue. I think you're talking about that transcripts.
Yeah, the same
Yes.
thing. So, and so you're supposed to go slow so that it is, whatever you say gets captured.
Yes, sir.
Sometimes that interrupts with your line of thought.
Yes.
So these are some of the things, when the setup, in the actual setup, it is very intimidating. Anybody feels, when I went, that was my first time I went there. What could they ask? Whatever they could ask is already there in the report.
Yeah.
And I've made the report. We did, my client did win that arbitration, but then I mean, this is a learning for me, and probably once I've shared.
Thank you, sir. And I requested Kiran ma'am, Silpa ma'am, that's Arun sir or the other professionals who have experienced that, they should share their insights, because I know values don't have the exposure in this testifying before the court, and this is very intimidating.
Yeah, Mr. Arun, thank you so
be...
much for your sharing.
Yeah.
Yeah.
Thank you, sir.
One
Thank you, Arun sir.
question that I have is, and will different people ask you questions, or is it only one person asking you questions in the tribunal?
So in the tribunal, there is normally just one person, the guy who's heading the, the proceedings from the other team side. So he's the guy who's asking, and other are like assistant lawyers who just constantly feeding him all the information.
And your report can be read in 100 ways you have not even imagined while writing the report.
Absolutely, that is what I'm saying. Whatever was written was not material. Whatever was not written was material. Another important thing is you are not supposed to refer to any documents.
Yeah.
You are supposed to go
Arun?
whatever you've written in the report off the top of your head. they will not allow you to refer to any documents.
So you cannot hold
So
your
that
report or refer and then say that so and so.
I cannot do anything. The first statement is you have written the report. You should know everything.
Everything.
And, yeah.
So now I
But-
understand when Dubey sir said that there should be even you should know your full stop and commas in the report. I think that is what you meant, isn't it, sir?
Yeah, and this topic needs lot of sessions, ma'am, and definitely I would also have certain ones. I will recommend it, and we luckily got Arun sir. Thank you, sir, for your sharing insights. But as a
One more
valuer,
thing,
yes.
just wanted to add there. So we had gone through one proceeding where we realized that you're not obligated to explain and convince the other party. Like how you
Yeah.
do through a conversation, right? Where you
Yeah.
say, this is why I said, and then go elaborate.
Yeah.
Brevity is something priceless there. We went through a mock arbitration before we actually went
Yes,
before the
yes.
arbitrator,
Yeah.
which is very, very useful. It is very clear. So anything you say, you keep it very brief and you say, whatever is there is already in the report.
Yeah.
And they can always look at the report. You are not bound to explain it and convince that other party during the arbitration proceeding. This was a priceless thing for us because by nature, we are consultants. We try to convince the other party, trying to explain why we did what we did. This is not required at all. This is what I say. Whatever is there is already provided in the report. Please look into it. Can be as brief as well. And whenever you tell something, they actually show you the transcript. You can correct it if required there itself.
Okay.
So you don't need to. It's like I told you can. The arbitrator gives you what he's going to type there. So you have to look at it and read it and confirm it there before it goes as a transcript there.
Okay, thank you, ma'am. Thank you for sharing it. And let me proceed further. And this topic is definitely is very have to be a lot of insights in that. Thank you, ma'am. Thank you, Arun sir. May I proceed?
Yeah, actually, one question to
Thank you.
Arun. Arun,
Yeah.
what kind of
Yes.
questions were you asked? Like just one or two to name and share.
First of all, they'll question your independence.
Yeah.
That's the first question they start with. And they're going to grill you on that, on that. So once you say you maintain your independence while writing the report, the second thing is you rightly said, as was rightly said, that they're going to question all your assumptions.
Yeah.
And they're going to present different. So assumptions cannot be, assumption is not a scientific thing, right? You cannot have 1 + 1 2.
Yeah.
And you can have your own set of assumptions, and there will be other set of assumptions that are also equally true.
Yeah.
And obviously, if there are case has gone in argument, there are two different viewpoints.
Yeah.
Obviously, the other party has totally different, pole apart opinion, and that is what they're going to grill you on. It becomes very difficult. You can say, these are my assumption, but that does not. You have to prove your assumptions. I mean, that is what I have experienced. You just cannot say, I can take my own assumptions within a certain range or whatever. I'm free to do it. That just does not cut ice. You have to
And sir,
explain.
just wanted to hear with the Arun sir's submissions that the opposite counsel's objective is not to prove that our report is wrong. Okay. His only objective is to raise a reasonable doubts in the minds of the tribunal. Okay. The alternative things may also be true. Okay. And if that is being true, there is a two possibility. The report or testimony given by the valuer is going to be ignored. That is basic. They are not going to prove our report is wrong. Their standard is different. Arun sir.
So I'm sorry, your voice broke. I could not.
And I'm again repeating. That is the I'm making that's a opposite counsel's objective is not to prove that our report as a valuer is incorrect. Their objective is to raise a reasonable doubt in the mind of the tribunal that there may be alternative perspective also, and therefore this report can't be considered in a holistic way.
You are correct in a
Audible,
sense,
sir?
but then if you try to think of it, yes, I
Yeah.
think the ultimate objective is to prove that the assumptions are completely baseless or wrong. I mean, that is the ultimate objective. I mean,
Agree.
that is what my experience has been. Because unless you prove that the other
Yes.
side has taken wrong assumptions, how do you prove that we are correct?
Yes.
And another
So I
point to
think
add is Karthikeyan here in Chennai.
Yes, sir.
I'm a valuer and I'm an arbitrator also.
Oh, great, sir.
With regards to council, their point, they have a set agenda. Anything that comes against the agenda, they try to either confuse the arbitration tribunal or the sole arbitrator, and they will mislead.
Yeah.
Because they have a fixed goal. Each council is moving towards a fixed goal, and if anything comes in their way, they are agitated.
Yeah.
Okay. So they try to mislead the tribunal.
Yeah.
That is the end point. So people who are going to present, who are going as a valuer to present their case, should be very clear. Which means they should have done the homework properly. They should have done the valuation by themselves instead of having pointed someone or having given it to their juniors to do it. And if they have all the points clear, there is no issues. They'll be able to answer everything, the basics. Because I come from Indian Institution of Technical Arbitrators, where the arbitrators per se are all technical, are from the technical background. So any technical issues we are able to understand. If a non-technical person sits in the tribunal, then you have to explain to them each and everything. That is the point where a lot of confusion happens. The technical person might not be in the position to explain technicalities to a non-technical person. There are two things. Explaining the technical issues to a technical person, explaining the technical issues to a non-technical person, because it has to start from the scratch. If that clarity is there, he can be able to arrive at the process of valuation, how we had arrived at the valuation. They should have such kind of a knowledge and the patience to explain and not jump from A to B to C to D. No, from A directly not to K. You understand? No? It has to go on a progressive way. So thank you.
Okay, thank you. Thank you, sir. Thank you. Sir, presentation is visible or not, sir?
Yes.
Visible?
Visible.
Okay, thank you. It's not showing. Just a minute, sir.
We are seeing the screen of estimation of economic damage and proximity cost.
Okay, thank you. Now, next is what are the components of the causations that may be the actual cause, legal cause, and both will forms the part of the liability. Okay, what is actual cause? This is the basically legal fact, questions of fact. Legal cause is basically the questions of law, and both will be part of the liability while we are deciding the quantum of the damages. Breach of contract and positions. One thing's very, very important. A lot of valuers who don't have the legal background, if you're going for this things, have a very thorough understanding of the Indian Contract Act, particularly other forms of the contract also, but how the contract flows, what are the insights, what are the nitty-gritties, what are the components, how the offer flows, and that basic understanding is important. But what happens when the contract is breached, that is very, very important. In case of a breach of contract and causations, and what relief the parties can claim. Normally, for example, there is two reliefs in general parlance the agreed party claims before the court. I'm not just talking about the arbitral tribunal, just putting the one questions. That is, one is the compensation, other is the specific relief act. We in India, we have a different legislation for that. Is the arbitral tribunal is empowered to give the special relief? Just putting one question. Can we claim it?
Are you referring to
Compensation?
interim relief?
Compensation definitely. Yes, ma'am.
In my mind, no, I don't think so. You can actually get a special relief.
A special relief. Okay. Any other viewpoint?
You're talking about that special damages kind of a claim by the court, is it?
No, ma'am. No. I'm not talking about the special damages. I'm called a special relief. Just
what is not mentioned in the contract?
Specific, like yeah. Specific relief. Yeah. Whether the arbitral tribunal can go beyond the contract and give certain relief to the agreed party?
Yes, interim
relief. No, unless until you
requested, interim relief can be given.
Okay, let me paraphrase. Okay, let me paraphrase in another way. Sometimes what happens, the courts base their decision on the basis of the principle of equity, fair treatment, equitable treatment to both the parties. They do justice. They don't do just to pass the orders. Okay. Whether the same thing can be done by the arbitral tribunal?
No. No, it cannot be done.
Okay. Yeah. Thank you. Other participants, please just ponder over it for the 15 seconds. Is it possible?
I feel it is possible. For the simple reason, sometimes the parties want interim relief.
Okay.
Whatever you call, whether it is
interim relief is different. I'm not. My question is not regarding the interim relief. I'm simply asking whether the arbitral tribunal can base their judgment, base their order on the principles of equity, fair treatment, equitable treatment to both the parties to bring to in the dispute. Normally, the courts have that power. Whether the same thing can be done by the arbitral tribunal?
I feel yes.
Can be done. We have very divergent views on this. Any other participants? Any other participants? The answer may be yes or no, both. But generally, the arbitral tribunal does not have the jurisdictions or power or authority to use the principles of equity, fair treatment, or equitable treatment to base their judgment until and unless parties specifically agrees to it. At Section 28 of the Indian Arbitration Act and globally also, every other jurisdictions have that the arbitral tribunal does prima facie, they don't have the jurisdictions. They have to go by specifically what is written in the contract. But they can go beyond only if the parties have agreed for it. So that we need to be very, very specifically with the arbitration agreement too. Okay. And regarding the quantum of loss, what are the theory, expectancy, reliance, and restitutions? These are three assumptions we take on while deciding the quantum. First is what is expectancy? Provide the claimant with the benefit of the contract. Okay, that is called in Indian legal term special damages for the loss of profit. Okay, that is called expectancy. Second is reliance, compensate the claimants for losses caused by the breach. Okay, that is because the ordinary damages, contract price versus market price comparison. And third is a restitution, return the claimant to pre-contract positions. Okay, so these are the three approaches or assumptions we have to take while deciding the quantum of the loss suffered to a party during the arbitrations. Expectancy, reliance, restitutions. Any learned participants wanted to share their insights on these three things if they have already went through it? Anyone? Yeah, any questions on this? Okay, let me go. Yeah, yes, sir.
You spoke about, if it is written in the agreement that they can use like principle of national
Sir, your voice is not that much audible. Please again.
Can you hear me now?
Sir, some disturbance, I think, in the connections.
Yes, sir.
Can you hear me now?
No, sir.
Yeah. It's audible, but not that clear way, sir.
Sorry, just give me a second and I will please go on. Just give me a
Okay, sir. So this is the expectancy, reliance, and restitutions.
Can you hear me now?
Yes, sir. Now better.
Yeah, no, I just wanted to know when there is a specific clause that, they can go on principles of natural justice or principle of equity, as you
The
suggested.
section 28 of the, if you are going to section 28 of the Indian Arbitration Act.
Right. Yeah. So, but are there restrictions even there? Because they still can't have the power of the, the court of jurisdiction. Would there be something which is still ultra virus?
Yeah, definitely. That means if the parties are silent or did not provide anything regarding this, then the arbitral tribunal is not empowered.
No, I understand. But even if they provide, would there be restrictions? Even if they provide like unlimited
then it depends how the arbitration particular clause is being drafted. Okay, that will decide.
Okay.
Yeah.
Thank you.
Yeah. Another sometimes just I'm a little bit diverging point. In every petitions we say that the court may grant such reliefs as it may please to pass in favor of the parties. That kind of a catch-all phrase remedies can't be claimed before the arbitral tribunal. We have to be very, very specific.
Correct. Okay.
Yeah. Next is the two distinct categories of damages in breach of contract: general, consequential. Each reflects a particular causal relations between the breach and the damages. Okay. Sometimes what happens, there is a contract between A, B, and C. If the contract between A and B is being performed, then B will be able to perform his obligation between the contract between B and C. What happens if A breaches the contract? B will not be able to perform his obligation in another contract with the C. That is called the consequential damages. Okay. So what will happen? B suffered a loss because the A breached the contract, and now B is bound to pay the damages to C. So there is a direct loss to A because the contract between A and B is breached, and there is a consequential loss because of that breach. B is not able to fulfill his obligation in another contract with C. Depending on the circumstances, either both or may be available under the expectancy of reliance theory of damages. There is a case law, Nelson versus Data Terminal. I will share this whole judgment, Silpa ma'am, to share the participants for this very interesting read, okay, on this particular point.
Yeah, sure.
Next is we have already discussed it, okay. Economic damages that are approximately caused by the breach and are natural or usual consequences. Usual refers to those harms that are reasonably foreseeable at the time when the contract is formed. Okay, you can't claim something which is not foreseeable, reasonably foreseeable at the time of inception of the contract. And I'm giving one very interesting example. There is a shipping contract happened between UK to India. What happens during the Middle East war? The Suez Canal was closed. The original contract was that the ship will pass through the Suez Canal. But what happens during the Middle East war? It was closed. Now the other party is forced to ship the contract via the Cape of Good Hope to India. The costing was totally different. Okay. At that time, the party refused to perform the contract, saying that it becomes impossible for me to perform it because I have entered into contract with reasonable foreseeability that it will be executed through the Suez Canal. But now there is war which can't be reasonably foreseeable. Therefore, I cannot perform the contract to Cape of Good Hope because that is going to be not economically feasible to me. That kind of argument can be placed both the way. Okay, but in that, or in course, I will say that also that court hold that the commercial impossibility is not impossibility. You have to perform it, but you can claim the amount of loss suffered in that performance. Coming to next, special or consequential. This is very, very important. Let me go another test that is called, let me just, sorry. Yeah. Sine qua non test. Okay, this is very heavy legal term. Sine qua non. That is a core, which is very essential things, without which the contract can't be performed. Yeah, which is forms the core of anything. That is called the sine qua non SQN test while deciding the quantum of the loss. Okay, if that act or wrongful conduct is the sine qua non or not, whether this is the main core thing or that is a consequential or remote thing, that need to be decided. For example, sir, what is the core, what is the consequential? Today is the mobile phone. What is the sine qua non for the mobile? Why originally it is a the device was made to talk to person, but now what happens? It gives the time also. Is it the watch? Giving time is a consequential things to mobile phone. Talking is the sine qua non. That's the core of thing. Mobile phone is also, we do a lot of emailing. Whether this is the laptop, answer is no. Okay, laptop also gives the time. Whether the laptop is a watch, answer is no. Which core function decides the character of that particular contract? That is very, very important while deciding the quantum of the loss. This is a sine qua non, and very beautifully explained Hadley versus Beck Stanley case, where this test was applied. Must read. I have will share to the Silpa map because that's huge judgment to read it, and I request everyone to read it. If you have any questions, because this SFT, that is a sequential fast test or sine qua non, is very, very important in that things.
Mr. Anil,
SQN test, but yes, ma'am.
I'll just give my understanding to all of this.
Yeah.
As a registered valuer, okay,
Yeah.
I should know all of this.
Yeah.
Accordingly, I give a justification, okay, this should be the compensation, because whether it is proximate cause or the real cause or this this test, and then accordingly I decide, I present my view, and then finally my conclusion is this is the compensation payable, because this is the assumption, this is the basis.
Normally what happens, we decide then value, man. Okay, first what is the cause, what is the quantum, and who is going and then this, as per me, this is the present fair value.
Okay. Yeah. So this also I should be aware as a valuer if I'm giving for a arbitration.
Yes. Yes. Yeah. Expert role, a causation, understand and prepare to explain. Okay. Wrongful conduct, how wrongful conduct cause damage. Logic that connects wrongful conduct with damage. Other factors that could have caused or exhibited the damage. Whether damages were reasonably expected to result from the wrongful conduct. Okay. Next is the expert role, expert testimony on causation. We have already discussed it. Just read for the 30 seconds. I prepared this, which I have experienced in one assignment, and with the transcripts of lot of matters. There's two parallel views regarding the testimony on causation. In first view, lawyers frequently instruct expert to assume causation. Second is that causation is a fact question that depends on the testimony of the fact witness. Third is causation is a legal issue upon which an expert should not opine. These are the one view. Another view is that financial expert, like basically SFA valuers, testimony quantifying damage lack relevance unless it is shown that damage resulted from the wrongful act. Okay. Failure to properly consider causation may jeopardize the admissibility of the testimony. Expert testimony may prove useful than fact testimony. Okay. This is very, sometimes what happens, experts are valued just asked on the point of contentions. What is the law? What is the standards? And what it happens? They are not required to give the opinion about the merits of the case. They are just given on that particular point. Like the doctors are regularly invited as a witness in the court proceedings, in criminal proceedings, basically. Next is reasonable certainty. This is very, very important. I have told that it's a damages are reasonable and they have been calculated using reliable factor without undue speculations. Lost profit do not require precision but cannot be based on speculations. There is no single measure of reasonable certainty. Is basically subjective. It depends upon fact and circumstances of each case. The courts require reasonable certainty, should not require too high level of proof, and at the same time should not accept the too little proof. Because every industry has certain rule of thumbs. Here the rule of thumbs, you whatever report you are making, that you should cross verify what is the rule of thumbs in that particular industry and whether that is falling within that rule or not. Reasonable certainty. Has the claimants presented sufficient evidence to award damages? Key factors: court's confidence that the estimate is accurate. Claimant has suffered at least some damage. Best available evidence of lost profit. Alternative method of compensation. Amount at stake. Degree of blameworthiness or moral fault of the defendant. Claim is supported by verifiable data. Claimant's track record. Established business versus new business. Projection risk. Bounded range of numbers supported by evidence. What happens sometimes when we get the projections from the client? I have seen a lot of clients, what they take the 1 year figure and then 10%. Every year they are going to increase the projection with the 10%. That is not how the things are done. In the past year the data, some year they have the 2%, some year they have 30%. They generally do it. If I get any projections which is made with that the figure and 10% every year they have increased, I just reject that projections. We have to be very, we should apply your professional suspicions while giving with the report. Every data should be corroborated. Next, lost profit versus business value. Lost business value. These are very important. Business damage claim, both can be claimed as a lost profit or lost business value. Generally, both are not allowed. Either you can claim as a lost profit, either you can claim as a lost business value. If you're going for both, court is not going to help it. Sometimes as a legal professional, in remedy part, they write as extensive as possible, but you have to be very careful. Yes, ma'am?
So I have one question for this loss of profit and the loss of business value, right? Can you give me some guiding principle as to why you would see? Ideally, one is whichever figure suits you is something which is a human mind decides. But how do you decide that approach?
Yeah, that's I've given that. If business is completely destroyed, then the proper measurement is the market value of the business. That is called the lost business value. If business is not completely destroyed, then business damage claim is the lost profit. Okay, that depends upon the quantum of the damage suffered by the claimant. If I am doing something and I'm not totally out of my business, then the lost business value. I'm in the same business, but my profitability has reduced because of the conduct of the defendant, then I'm going to with the lost profits, which the Indian Contract Act also acknowledges under the Section 73.
Thank you.
Yeah. Next, we have the while estimating damage, ensure that claims are not counted twice. Double recovery of damages is not allowed. Claim for diminution of value of a business are lost profit claims. Okay. Lost business value claims apply only to the destruction of a business. Inceptions, this is the one I will explain with the one example I have taken it. Damage time period, damages time period. This is duration of breach and duration of damages is also very, very important. TDP and DID. For lost profit, typically damages time period is for a specific or limited time period and not perpetuity. Okay, what is the duration of the loss when you have suffered it? Okay, that is very, very important in estimating the amount of the quantum of the loss suffered by the claimants. It should be specific timeline. Okay, suppose 1 year you not able to pass certain examinations. You can't be in perpetuity. I failed that because of that person. Okay, next year will get the opportunity. So you can claim only up to 1 year. You are not going to claim it up to perpetuity. For lost business value, the time period runs into the perpetuity because you are completely out of your business. Business are basically going concern basis. Therefore, you can place in that, but not in case of loss of profit things. Damages time period has important implication for revenue and cost measurement. And lot of escalation damages claim in the construction contracts. This damages time period comes into picture in a big way. Whether lost profits apply only to contract period or it has implications beyond that contract period, that need to be considered while estimating the economic damage. Estimation, this is a summary. Okay, understanding the background of the case, link between causations and damage, type of damage, acceptable damage theory applicable to jurisdiction, practices, method accepted by professionals, peers, and academics in that particular industry, undisputed fact, estimates, assumptions, foundation of damages. We need to do the analysis on these certain aspects. These are just indicative. Okay, on particular assignment or a particular case, there can be the more than that. Summary damages, expectations, I will discuss a little bit later on. Let me, punitive damages, I will come. Let me go to the last slide. You will get this. Before that, I wanted to discuss these things. Okay. Damnum sine injuria versus injuria sine damnum. I think everyone had read it or not. Damnum sine injuria, injuria sine damnum. Anyone? I think anyone who's from legal background, they must have heard of it. Any of friends? I need the answer. I'm audible?
You are audible. We do not have answers.
Okay. This is very interesting legal principles in the damage estimation. One is called damnum sine injuria. Other is called injuria sine damnum. Damnum means damage, that is a loss. Sine means without. Injuria means violation of legal right. Just a minute. I think. Yeah. My chart was not. Okay. Damnum sine injuria. Damnum, again repeating, friends. Damnum means damage, that is loss. Sine means without. And injuria means violation of your legal right. And another is injuria sine damnum. What happens? Sometimes there is a loss to you, but there is no violation of your contractual or legal rights. That is called damnum sine injuria. Example is very simple. Suppose you are having a monopoly, you are having only shop in your vicinity or in your locality. Some other persons comes, he also opens a shop. Now there is a competition. Now you're going to have some loss because you have a monopoly earlier. Now you have a competition. So your margins are going to reduce 100%. Earlier, like in insurance business, LIC was the only player. Therefore, entire business going to LIC. Market was open. A lot of private players are there. Now that LIC is a big player, but still there is a huge competitions. LIC's margins have reduced. Okay. That is called the damage. Damnum sine injuria. There is a loss to you, but there is no violation of your legal right. Okay. Therefore, can you claim compensation in this scenario?
No.
There can be no claim. Okay. This is called damnum sine injuria. And opposite to damnum sine injuria is a principle called injuria sine damnum. Here, there is a violation of your legal right, but actually there is no damage to you. Okay. So let me put one political example here. For example, you are a voter in your in any election. Okay. What happens? You wanted to cast your vote in favor of a particular candidate. You went to the booth, some way, other way, wrongfully, you have been denied to exercise your voting right. But what happens? The candidate you wanted to vote, that candidate won the election. So there is a violation of your legal right, but there is no loss to you. So what should be the amount of compensation here?
Nil.
Because there is no loss. I'm getting, I hope I have cleared my examples. If anyone has any problem? In first case, damnum sine injuria, you can't claim any compensation. because there is a damage, but there is no violation of your legal right, contractual rights in that way. That means in arbitral proceedings, if you're placing any damage, then it should have a contract clause which gives the empower you to claim that compensation. If there is no contractual rights, you can't claim that. So first you have to see which clause gives me that particular right. Because if that is you're claiming a lot of compensation, but there is no legal backing for that, then it's not going to stand before the court. There, that is covered under the damnum sine injuria. Now coming to the injuria sine damnum, it's completely opposite. Yeah.
Can you please repeat that example that you told, sir, about that election?
Okay, ma'am, suppose you are there is an election. Suppose just we conclude the Lok Sabha elections. Okay. In the Lok Sabha elections, you are a voter as being the citizen of the country. You went to the polling booth to cast your vote. But polling booth, the officer told you wrongfully that your name is not in the voter list or something like some other pretext. You wanted to vote to particular candidate. After the election, your result, that particular candidate won the election. But you are not able to exercise your voting right. There is a violation of your right. Wrong
Fundamental
has been done
right.
to you. Wrong has been done to you. There is a violation of your legal right. But problem is that you have not suffered any loss because the candidate you wanted to cast your vote, he has won the election. So what will be the amount of compensation in this case? There is a lot of situations where there is a violation of your legal right, but actually you did not have there is no loss to you. So what should be the amount of compensation in this case?
There is no compensation, only is what I think.
There is no compensations. Any other view? Any other view?
I think there should be compensation because there is loss of something which is intangible. Actually, rights is
violated.
Disturbed.
Agree. Any other things? Any other viewpoint? The point is that in this case, job of valuer is actually very easy. Okay, because there is he has not to estimate the amount of the loss because no loss has been suffered. I'm not taking deliberately another example, another aspects of that example, because that will drove our discussion in totally different directions. If that particular candidate whom the madam wanted to cast vote lost the election and just by one vote, okay, then what would have happened? I'm just reserving that questions. I'm not going into that territory because that will also come into picture. This is technical language called, sir, 100% the amount legal right is being violated. The party is entitled for compensation, but no loss suffered. Therefore, the amount of compensation will be nominal only. Okay. It is not going to be very substantive. Sometimes a 1 rupee compensation is given by certain in court orders. Okay. I'm not giving one very famous politician. He was a professor in Delhi, IIT Delhi. He was removed in 1972. Okay. And he fought for 20 years. And finally, when the court given order in his favor, he just taken rupee 1 as a compensation just for the recognition of his legal right. That means the wrong has been happened to him. Okay. This is very, very important as a valuer to understand these legal principles. I will explain types of damages. What are the compensation basically available in normal court or arbitral proceedings? Okay. I have written third damages, nominal damages. That is basically the injuria sine damnum. That means generally not you will get only 1 rupee or 2 rupee just for the recognitions. Okay. But nominal damages generally not given by the arbitral tribunal. These are basically given by the courts. Okay. Because here the court will decide the amount of the loss. If there is no loss, they are not going to give you any compensation, even for the nominal compensations. Okay. The nominal damages are beyond the jurisdiction, unless otherwise agreed by the parties, beyond the jurisdictions of the court. The injuria sine damnum is applicable in court proceedings, but generally it's not by the arbitral tribunal. Next, coming to the Another example, that means if your candidate have lost, and not by just by one vote, okay, I'm confining my example there, that is called exemplary damage. That is a punitive damages. That is it is given with an intention to give a message to the society. This is also beyond the jurisdiction of the arbitral tribunal. This is in the jurisdiction of the court. Court can give this, and here the amount of compensation are very high. Nominal very low, exemplary is very high. Purpose of both are totally different. Okay. Then we have the liquidated damages and unliquidated. I will come to ordinary and special later on. Liquidated damages and unliquidated damages. What is this? Anyone? Liquidated damages and unliquidated damages.
Liquidated damages is where you are actually not able to perform the terms of the contract, where maybe it is all contained. Even the terms of the damages that need to be paid is defined in the contract for not having met the terms.
Any other viewpoint on this? Liquidated damages and unliquidated?
Liquidated damages are ascertainable. Computation can be done, whereas unliquidated we cannot compute in advance.
Okay, you're right, sir. That's a liquidated damages when the parties have already fixed the amount of compensation in advance. If there will be breach, party will pay suppose 10 lakh rupees as a compensation. Okay, so what happens as a valuers, we don't have much role in case of liquidated damages. Unliquidated damages depends upon the discretion of the court, depends upon the quantum of the loss suffered by the parties. Okay, in case of unliquidated damages, the valuers have a huge role to play. Okay, so we wanted as a valuer, party should not have the liquidated damages. Okay, that reduce our market. But in case of unliquidated damages, it's not ascertainable in advance. Therefore, valuers come into the picture. This is very, very important things. Another ordinary damages and special damages. Ordinary damages basically contract price versus market price. Everyone have heard about it. If there is a contract in A and B fail to perform the contract, then what will happen? A has to sell into the market, and what is the difference between the contract price and market price? He has to recover from B. Special damages, we have discussed that for loss of profit. Suppose there is a contract A, B, and C. The previous example, A breached the contract, therefore B is not able to perform with the C. Now B has suffered not just the benefit from A, but also the profit from the C. Therefore, he can claim as a special damages. These are the legally recognized principles under the Indian Contract Act while compensating the agreed party. This is very, very important. Any questions on these points? Damnum sine injuria, injuria sine damnum, and this type of damages? Any questions, sir? Now I'm coming back to the time is one practical example. Yeah, this is the practical example before everyone. Okay, just go through it. Okay, for 1 minute. I'm coming just 1 minute. Just go through this example.
Mr. Anil is back. I just had a few announcements. For those of you who are not BVA members and who have joined this session, we request you to become a part of our association. Please get in touch with our admin, Ms. Vijaya, or visit our website, bangalorevaluers.org, and be a part of our association. Thank you.
So can anybody tell me what is DAD and DND? Mr. Anil told two things, right? DAD and another. I think we should wait for him to ask.
Today's session is indeed a wonderful session. All of this, Mr. Anil, we are still wondering the abbreviations what you have used.
Okay. That's
Sir, please, once again tell us DAD, and you also told us another terminology. So DND or
just a minute. Why it is not coming? Yeah,
it could be for date of damage.
Yeah, a date of damage. Yeah. Okay. There's one thing that we need to be. Just a minute. Sorry. Some issue.
Anil, what do you have any concern?
In my system, it's not a presentation is not getting updated. I'm sharing it again, ma'am. Just a minute.
Yeah.
Why it is not being?
Actually, we can see that estimation of economic damage.
But okay, let me see it separately because I'm not able to see it.
Okay.
Okay. Yeah. Yes. Yes, ma'am. The question is date of breach, April 2, 2018. Just I'm giving the hypothetical example. Date of trial, yeah, that's June 15, 2020. Date of final judgment, January 15, 2024. Damages period and date of damage. This is a April 2. Damages period, April 2, 2018 to April 2, 2023. And date of damages, April 2, 2018. Okay. Discount for 5 years plus pre-judgment interest for the period April 2, 2018 to June 15, 2020. These two components will form the part of the damages. I'm taken from one judgment. I'm not able to putting that. They have given this kind of in arbitral matters, kind of analysis while doing the damages analysis. Okay. Again, in that point, DAD is date of damage. Okay, date of breach. Okay. They use that terminology, therefore I've taken from that.
So DOB is date of breach and DAD is date of trial.
No. It's basically DAD to take is a date of the breach. Okay. Because it's a European case law, they don't use in particular English format. Okay. Yeah. Forget about just the synonyms, just abbreviations, just focus on the concept. I will share this case law also. Okay. Just for the practically how the valuer has applied that in the breach of the contract spheres. And what will be the discounting rate in case of the discount for 5 years in this case? Because as a valuer, you need to own the discount rate. Discount rate of party A, a discount rate of party B, or discount rate of the industry in general.
That discount rate, the way we calculate normally, that is risk-free rate of interest for 5 years security, whether as per RBI.
Yeah.
And then plus whatever, what should I say, beta of that when market rate.
There's a cost of, so you're going, that's fine, cost of equity. But sometimes we need to adjust that calculation with the company specific or asset specific risk premiums. Okay. That may vary. Yeah, that may vary as per the clients. Okay.
Very true, very true. That is depends upon the industry.
Yeah, so in that situations, the discount rate we are going to use here, that is for party A, it will be a party B or what? Because there is a huge, I'm just deliberately, because time was less, kept outside that questions, but court was not very much sure. Therefore, they go with the industry average standards and taken party neutral discount rate. Okay, in that matter. But court also say that this is not the should be taken as a precedent in that particular matter. Therefore, as a valuer, if you are going to decide the discount the cash flow, in that matter, we should be very, very careful with the company, the specific risk premiums we are going to adjust with the cost of capital, that need to reflect in general to the industry, not to particular party, unless otherwise provided. This is the point. A lot of practicals, because I today wanted to give the theoretical background. Sir has told me to give the more practical aspect. I think one more session or 2 sessions will be taken to hear how hardcore practicals. I'm going to a lot of transcripts basically in the international arbitrations, how the valuers going to have testified, the huge bulky material, I think 10,000 pages. I'm going through it, and when the presentation is ready in that practical aspects, will again disturb the Silpa ma'am and sirs for the another insights. Any questions on these discussions, friends? Yeah, any suggestions you wanted to share it? Because it's totally different field, uncharted path, and yeah.
I just want to ask one question.
Yes, sir. Yes, sir.
Now, damage assessment.
Yeah.
Who is capable or who is the right person?
Yeah.
All of us are valuers, but one
Yes,
is valuer
agree.
of a land and building, another one is plant and machinery, another one is SFA. Now, of all these three, who is the right person to ascertain the damages or quantum assessment?
Answer is that, sir, all three. All three.
ऐसा नहीं होगा.
Depends upon the nature of the asset. All three. Yeah.
Okay.
All three. Yeah. Because it's not the domain, because lot of the construction or the equipment industries, the coming import and export, the plant and machinery valuer has a huge role to play. Yeah, I have seen that every commercial contract regarding the equipment and constructions, plant and machinery valuers have they are engaged in full time, that kind of things.
Yeah. Okay.
Yeah. In case of the investment agreement, in case of an investment agreement, so particular investor state or between the investors cross border, it's SFA valuer is going to play a big role. Okay.
Yeah.
Land valuers, I think depends upon the contract, not that much, because it's not that frequent things will not happen. Any other questions?
I would like to add one more thing, Mr. Anil.
Yes, sir. Yes, sir.
Land and building valuers do have a big play in construction contracts. Construction contracts per se today are very huge. For example, you take national highway contracts and other things where arbitration comes in. It is they play land and building valuers play a major role
in construction. That's fine, but I'm asking about the international commercial arbitration aspect.
International commercial arbitration, yes, depending on what the commerce is, whether it is the industrial side or the construction side.
Yeah, agree. Yeah, thank you. Yeah, with this, thanks a lot. First of all, to the Bangalore's Valuer. It's a sheer pleasure to be among such a great. And I like, because sir, I wanted to make the interactive, because a lot of things gives us the insights to probe further. What are the kind of questions? And Atul sir has given a lot of testimony, because that was the point. I will, sir, put in chat box your number. I will talk to you on this, because I have a lot of questions. Okay, you have personally experienced it. That's really nice. And Silpa ma'am, really thanks a lot, and keep doing this great job. And joining Saturday and the morning, that's really commitment. In Kolkata, this is, everyone has asked me. Even I have put the alarms to be awake in the morning. I hope I was not sleepy enough. Okay, in the sessions. Thank you. Thanks a lot. Thank you very much.
Anil
Sir, one last question.
One question.
Yes, sir.
So I just want one question. So is there any particular detailed course on this arbitration valuation where the entire process and entire the practical aspects and everything would be covered? That's the first part. And the second part, if there are certain valuation things are covered in any particular valuation arbitration order, so whether those orders would be publicly available for us to go through it?
Okay. So let me answer the first question.
Yeah.
Sir, I have just gone through the international arbitrations, but I have told to the Vienna International Arbitration Center in this aspect to have launch. They are figuring it out, but they have not come it out. When it comes, I will definitely say to the Silpa man to pass. ICCC is also considering, but not yet formally announced. Okay. That's how the valuers, they are not just valuers, they are going with the expert witness, and they have Chartered Institute of Arbitrator London has issued one detailed document regarding the independence and objectivity of the experts, including the valuer. So not formal courts, sir. I'm keeping in mind, if that comes, definitely I will share, but right now not in my mind. And second point is that to get the case laws from where this lot of judgments where the valuations testimony and valuation calculation has been said, that is a real problem with the arbitration, because the proceedings are confidential.
Okay.
Like in court proceedings, these are the public document, but the arbitral tribunal proceedings are not public document. So you have to, I'm applying my connects networks to get as much information as I'm getting it. And because every proceeding and a lot of things I'm not able to quote and share it also, because of the confidency clause, because the friends who have given to me, they have given on that anonymity and confidentiality. I have to maintain it, but this is the concerns, because the nature of the arbitral proceedings. So we can take the help of the court proceedings in the different jurisdictions. And if anyone gets any transcript anywhere in the arbitral proceedings, so please try to get hold of that, because there is a lot of learning and insights in these transcripts, how the parties, how the tribunals, how the valuer or other witnesses go about it. So that is basically the gold mines for the learning, if you get the transcripts of a particular arbitral tribunal, but publicly it's not available, sir.
Okay. Thank you, sir.
Mr. Dubey, I just want to mention
yes,
that
sir.
I think ICCID is the only one institution where they publish the awards.
ICCIDs are published, and that transcript is also available. And but ICCID, what happens, sir? Mostly the government and the semi-government institutions are there. So that's not that useful, but others don't publish it. Agree. And because they publish it, because that is ipso facto enforceable in the respective jurisdictions.
Very good. Right.
Yeah. Any other suggestions? But keep it. I will suggest to follow certain arbitral institutions in regularly, like ICCC, Singapore, Chartered Institute of Arbitrators, London, Vienna International Arbitration Center, VIAC. These are the very good arbitral institutions. Particularly ICCC, sir. Here, what happens? For example, if any parties are not agree to particular things, they immediately go to High Court. When go to the High Court, it will create long delays. Okay, judicial delays. That's ingrained in the system. They don't have any outside interference. Court within the arbitral institutions, you can make an appeal, and that will make the final decisions. And I wish all the valuers to get a lot of assignments, international arbitrations, because money will not be a problem, I'm sure. Okay, the kind of assignments, and I hope everyone gets that. And good exposures. If anyone get it, Silpa ma'am, please request them to say to the valuers organizations, and will be benefited in return.
अनिल जी, जितना आपने सब समझाया ना, अभी लग रहा है कि ये ना ही करे तो बेटर till the time we are really having many more sessions.
My point,
get a hold of it, and then actually.
And then I'm trying to get some arbitrators or valuers who testimony to part of their team, basically how the things will start to part of their team, how they proceeds, learn from them, and then go solo.
Surely.
Yeah, sir, I just had one question. I think that this question could have been better answered by Mr. Arun or Atul, who has the experience. So, in case of an arbitration, there will be two parties, and there will be two people who will be appointed as arbitrators, right?
Yeah.
And they are the ones who are, and will there be another person who is like a judge who will be listening to both of them, and he will pass on final order? Or it is just that there will be a mutual conciliation that actually happens
what happens,
between both the parties?
It may happen both the way. That means sometimes there is a sole arbitrator appointed by both the parties by consent.
No, may I answer this?
Yeah, please.
There are two arbitrators appointed by each party, and in a tribunal, it is not even number; it is always a odd number. So both of them will come together and appoint a third arbitrator. He is called the presiding arbitrator. And again, as Anil Kumar was been saying, arbitrators are not counsels to the parties. Arbitrators are highly independent people, just like valuers are independent. We have arm's length transaction with the parties. Here too, they have arm's length transactions. They are not taking fees directly from each party. It is pooled. The amount is pooled, and then the fees is being paid by the institution or by the presiding officer. So they are not answerable to each party. Just because someone appointed me, I am not answerable to him. I am not.
Agree.
Okay. So the presiding officer. Yeah. Thank you.
And sir, just one point, that presiding officer and other. It's just minutes, sir. The distribution of fees, how the fees had distributed among that 40% goes to the presiding officer, 30% is to the party appointed arbitrator.
You play or you don't play?
Trained in the industry. Yeah. Sanjay ji wanted to say something?
No, sir.
Talking to some other person.
I'm sorry. My apologies.
Okay.
Yeah. Actually, Mr. Anil, you muted yourself.
Yes.
On behalf of Bangalore Valuers Association, I request Mr. P. Karthikeyan to extend vote of thanks. And Mr. Anil, you can stop share, or you can share your contact details also, just in case you're comfortable.
Okay, that's in presentations that I'm just saying that. Okay, I will share the PPT, ma'am. Just share to all the participants just for their knowledge.
Sure.
Okay. Yeah.
Okay. Good morning, everyone. At the outset, I'd like to thank BVA Association for organizing fortnightly basis a beautiful lecture series. This is a Herculean task. Fortnight after monthly, twice you are having fantastic lectures, and in the morning, it is really not many organizations are able to do this.
Yes, agree.
Pan India, we've had membership in different organizations. On a fortnightly basis, we don't have this kind of arrangement. And we should thank BVA, President Shilpa ma'am, for organizing such events on a regular basis. On a regular basis is the important thing. People organize, might be once in a blue moon. Okay, here, the blue moon is every fortnight. Okay, congratulations. And the topic was a real good topic, very near to me, because I was the past Joint Secretary General of Indian Institution of Technical Arbitrators, Chennai. It is a pan-India organization of technical arbitrators. We train. The members are basically engineers. We technical people. We gather the technical people who are senior, who are in the senior HOD level, and we train them in arbitration proceedings. The reason for this is non-technical members are not able to understand the nuances of technical thing, and a lot of time is being lost in explaining the technical aspects to the arbitrators. That is the reason this was formed in 2001 by one engineer, Velu, who was the head in Chennai Port Trust, and we have a very strong association in Bangalore also. Might be some of members will be here also. Okay. And coming to Mr. Anil Kumar's presentation, it was really fantastic presentation.
Thank you,
He,
sir. Thank you.
yeah, he had introduced.
Blessings, sir.
Yeah. He had introduced the points point by point, and it was really good. But arbitration, there are two things which we need to understand with regards to arbitration. Arbitration in India per se is in a very nascent stage. It is not grown as it was expected to grow. But there were two reasons. One was the arbitration rule was before 1993, 1996 Arbitration Conciliation Act was way back. It was very old. Okay, so the 1996 Arbitration Conciliation Act came into force, and we've had quite a lot of amendments in that also. And second thing is, to be frank enough, there are a lot of internationally arbitrators are by profession the arbitrators. Here, arbitrators are retired judges. Okay, and once the judges come, they move the arbitration proceedings as if it was court proceedings. The purpose of arbitration is, it is a system where when you go to court, it takes a long period due to many number of reasons, because of the pendency of the cases and so on. They come to arbitration. Again, arbitration should be short and sweet. Arbitration Conciliation Act says you finish the entire proceedings in a time frame, but it is not being done. So,
sir, just one correction. Arbitration is concept is very old in India. We have the arbitration 1940. Even before that, more than 100 years. But the works on ground is not happening that way. That's nationalistic. That's agree. Yeah.
Correct. Yeah, I mentioned in 50s we have an arbitration rule, but for many reasons, because 50 was immediately post independence. Okay, and courts and other things, they started ruling, and delay causation, and it got delayed. Okay, so going to the court is now a Herculean task, and arbitration is a fantastic thing. In fact, we need to develop on arbitration, and a lot of scope remains to develop on arbitration in India. And such many lectures are a need of the hour, because BVA per se has a group of valuers from all three areas. SFAs.
Definitely.
Okay.
And the way, sir, I also talk to a lot of arbitration people. The BVA is working it, because every fortnight I get the mail from the BVA having these programs I have attended. Sometimes though, I'm sorry, attend because sleeping and listening both the same happening the same time. Okay, that's but the kind of consistency and commitment, that's really incredible. Yeah.
Yes, I think we need to have one more session where we introduce arbitration, the process of arbitration to BVA members. How it starts, how it ends.
Agree.
And appointment of arbitrators. From appointment of arbitrators, informing the parties and the councils, the role of councils, the role of parties, role of arbitrators, the proceedings, how it ends, what is judgment. We don't call it a judgment, we call it an award in arbitration. How the award is given, and what is the power of the award. Once the
and sir, another point, sir, as you told, you are valuer as well as arbitrator. As a valuer, we have a natural advantage while being considered as a post of the arbitrator, because we understand the technicalities and numbers. So that helps us parties to consider the valuers to be appointed in the tribunals. Yeah.
Correct.
I agree.
So what we'll do down the line might be we can have a series of lectures on arbitration. Yes, and introduce arbitration in toto so that people, members have a total clarity on arbitration and its role. Okay. And thank you, Mr. Anil Kumar. It was a fantastic lecture.
It's my pleasure, sir. Keep blessing.
No. Sharing.
This is
sharing is nothing but lighting 100 lamps with one
I
lamp.
really like to thank Neeraj because he told me, sir, you have to share certain things because I told them I have only one concern to wake up in early morning. But sir, you can manage it. Just do it. Okay. Then he connected. I'm thanks to you, Silpa ma'am, Neeraj, for all the efforts.
So thanks to Mr. Neeraj Agarwal and our VP Education Ravindranath for organizing such a wonderful session. On behalf of our association, our admin will be in touch with you and share a token of gratitude, this memento which we are sharing on the screen.
Thank you, ma'am. Thanks a lot.
Thank you, everyone.
Thank you.
Thank you.